Swayam Prabha. Digital India. Educated India.
Well, students, this is Dr. Ajay Kumar Singh, Assistant Professor, Faculty of Law. So, today I am going to discuss custodial violence in prison and human rights issues. This is my 14th lecture, and in this lecture I would like to discuss rights of prisoner and human rights problem. So, first of all, I would like to discuss rights of prisoner which they are entitled to get from the authority concerned, from the jail prison authorities. In prison they should be safe, and so rights of prisoner, and then after we will try to understand that custodial violence is committed against the inmates of the prison. If custodial violence is committed against the prisoner in the prison, then what would be the consequences, what would be the remedies available to the prisoner. So, with the help of this slide, you just look at this slide. I have referred this custodial violence in prison. So, custodial violence, the word is not defined, but it appears in different forms. Custodial violence may appear in form of death, death of prisoner in prison due to assault or due to custodial torture. Many times you might have seen that physical torture or prisoners are assaulted by either by the inmates, other inmates of the prison, by their fellow prisoners or by prison authorities. Sexual abuse like sodomy, and they are involved in this kind of activities. So, these are three important areas where cases regarding custodial death in prison, custodial torture of prisoners or sexual abuse of the prisoners occur in within the four wall of the prison. Now, next important thing is that human rights of the prisoner as provided in UDHR, Universal Declaration of Human Rights, and under Constitution, Indian Constitution, right to life. Every person has right to live with human dignity, right to life, right against torture or inhuman treatment, Article 5. You need to remember this article. Article right to life, Article 3 UDHR and Article 21 Indian Constitution. Right against cruel punishment, Article 5 UDHR. You need to remember this Article 3 and Article 5. Right to safety, that is paramount concern of prison authorities, that is paramount concern of state, that prisoners should not be killed in prison, prisoners should not be assaulted in prison. So, safety concern is very important. Right to safety, right to food if they are prisoner, right to free legal aid, right to legal aid, right to free legal aid. You see, these are certain rights which prisoners are entitled to get from the authority concerned. They cannot deprive, prisoners cannot be deprived from these precious rights only because of prisoner, only because of wrongdoer. They are entitled to all these rights because of that presumption, presumption of innocence. Article 11 talks about presumption of innocence, that is human right. So, every person, every accused must be presumed innocent unless his guilt is proved before the court of law. So, because of that presumption, prisoners are under trial prisoners and convict prisoners are also classified into two categories: under trial prisoners and convicted prisoners. So, under trial prisoners are not convicted, they have not been convicted. So, they are entitled to get all the benefits from the benefits here means all the rights from the authority concerned. So, what rights which prisoner can claim against the authority, I have highlighted those rights. Now, come to the forms of violence which occurs in custodial violence in prison. So, you can see this custodial violence in prison, and there are two important case laws. With the help of this slide, I will try to give you entire information. Khatri versus State of Bihar IR 1980 and Hussain Ara Khatun versus State of Bihar IR 1980 Supreme Court. Right to, in this case, in Hussain Ara case, you all might be aware that right to speedy trial was recognized as a fundamental right under Article 21 of the Constitution, and this Khatri case is also popularly known as Bhagalpur blinded prisoner case. Now, come to this Khatri versus State of Bihar. You see what actually happened in Khatri versus Bihar. Police who were involved in, officials who were involved in that incident, they had assaulted, they had used illegal means to obtain confessional statement from the under trial prisoners, from the suspect. So, in this Khatri case, Khatri versus State of Bihar, many means about 12 prisoners, they have lost their eyes. They have lost their eyes because police investigating officers, they had assaulted them. They were, since they were poor, they were not in position to engage their counsel. So, their grievances, their matter was brought into the notice of Kapila Hingorani. She was a leading lawyer at that time. So, she decided to fight their cases, and the matter was brought into the notice of Supreme Court that officials who were acting on behalf of the government in this case, they committed that crime, they should be prosecuted and convicted for wrongful confinement as well as for grievous hurt which they had caused to the prisoners. Since many prisoners, they had lost their eyesight permanently, so they were referred from Patna Medical College to Delhi for their treatment. When Supreme Court intervened in this matter, that they should be referred from Patna Medical Hospital to Medical College to Delhi for their better treatment. And when their treatment was going on, an investigation was also going on. So, police investigating officer filed a petition that they should be sent back to Patna, Bihar, so that investigation can be concluded within time frame or within stipulated time, expeditiously. But you see, those victim of crime along with Khatri, they refused to return back. They had apprehension that they might be killed or they might be assaulted by, again they might be assaulted by police officers who were investigating the case. So, they refused to go back. And in this case, this is the important facts, these are the facts of this case. So, the point which you need to remember is Supreme Court in this case for the first time recognized that right to legal aid, free legal aid is a fundamental right, essential component of right to life and personal liberty. And you see, just few years back, 2 years back in 1978, Supreme Court had already recognized right to free legal aid as a fundamental right in M.H. Housecott versus State of Maharashtra IR 1978 Supreme Court. And Supreme Court got opportunity to decide this case in 1979, and Supreme Court was very much aware about all the facts which were brought into the notice of Supreme Court, that all the accused were poor, they were not in position to engage their counsel in the lower court. So, Supreme Court for the first time recognized that all the accused are entitled to get free legal aid, and state concerned is under a constitutional obligation. It is not a charity. State governments are constitutionally bound, obliged to provide free legal aid to those people who are unable to engage their counsel on account of poverty. Due to poverty, they cannot engage their counsel. So, it is the obligation of states are obliged to provide free legal aid to those underprivileged people, those people who cannot afford court fee or advocate fee. The important thing is that in this case, Supreme Court held that it is the right of accused suspect to call his counsel advocate at the time of interrogation. The moment interrogation begins, at that very moment, suspect or accused has right to consult from his lawyer. He can have his own lawyer at the time of interrogation, and this right is available to the accused suspect till the completion of trial. So, right to have a counsel, right to take legal assistance from counsel, it starts from investigation and it continues till the completion of the trial. This precious right is as important as right to life is important for a human being. So, no suspect, no person can be deprived from this precious right, that any person can have his own advocate, lawyer, right from the interrogation until the completion of the trial. So, this is the first case where Supreme Court has categorically held that this right can be availed, right to free legal aid, right to have a counsel, right to take legal advice from counsel at the time of interrogation. You see, it will be helpful in two ways. The presence of advocate in that very room where interrogation is going on, where police is interrogating the accused or suspect, the presence of advocate will avoid the chances or possibility of police atrocities, custodial violence. So, mere presence of advocate will avoid the custodial, any kind of custodial violence or police atrocity. Secondly, it will boost up level of confidence of the accused or suspect that police, that his counsel is present in that very room where interrogation is going on. Police will not use any third degree method against that accused. So, you see, having all these consideration in mind, Supreme Court held that accused should be allowed to have a counsel at the time of interrogation, at the time when interrogation begins, and he can have his advocate or counsel till the completion of the trial. This is the beauty of this judgment. And the third important, the first is right to free legal aid, second is suspect or accused can have his own counsel at the time of interrogation till the completion of trial, and the third important thing is that Supreme Court directed the government concerned, state of Bihar, that Supreme Court did not accept the plea of sovereign function. Police officers, they were acting on behalf of the government, they were performing government duties, they are performing sovereign function. So, state would not be held responsible for that. Supreme Court did not accept all these plea contentions, and Supreme Court held that state government is vicariously liable for the wrongs committed by its servant. So, police officers who were involved in that incident must be held liable for their wrongful act. they not only be compelled to provide compensation to the victim of crime, but they must be prosecuted and convicted for the crime committed by the police officers. So, you see, the important point is that all the victim of crime, they got compensation from the state, and state had to provide compensation to the victim of crime. So, this is three important things which you need to remember in Khatri case. The first is right to free legal aid, second is right to have a counsel at the time of interrogation till the completion of trial, and third is right to get compensation in a crime. In case of crime committed by government officials, they can get compensation from the state. So, these three things you need to remember in this Khatri case. Another important case is Hussain Ara Khatun versus State of Bihar, AIR 1980 Supreme Court. In Hussain Ara case, what happened, you see, the plight of female prisoners. Hussain Ara Khatun, she was a female prisoner and she was languishing in jail for so many years. She had no idea about, she was ignorant about her rights, and when petition was filed by Kapila Hingorani in this case, Kapila Hingorani, the one important thing which I want to explain you, Kapila Hingorani is considered as mother of PIL in India. So, when she inquired, when Kapila Hingorani inquired in this case, Hussain Ara case, she found that many female prisoners, they were languishing in jail, different district of Bihar jail. They were languishing in jail for so many years. They were ignorant, they were poor, they were not in position to engage their counsel. So, due to poverty, they were languishing in jail. So, if they would have been convicted by, they were under trial prisoners, if they would have been convicted by the court, they could have been acquitted by the court, they could have been released by the court, because they were languishing in prison for so many years. For example, where an accused who was languishing in jail for committing theft, and the maximum punishment for theft is 3 years, and that accused is waiting for his trial for more than 3 years, let us say 4 years. So, you see, he should have been released after 3 years, because the maximum period prescribed for the theft is 3 years punishment. He should have released after the expiry of 3 years, but he was not. So, in this similar situation, Supreme Court said that right to speedy trial, that is essential component of right to life and personal liberty. Where matter is not expeditiously disposed of by the criminal code, it would be a violation of right to life and personal liberty guaranteed under Article 21 of the Indian Constitution. Justice delayed is justice denied. From there, Supreme Court derived the authority to recognize this right to speedy trial as a fundamental right, as essential component of Article 21 right to life and personal liberty. You see, the personal liberty of any person cannot be curtailed for an unlimited period. So, Supreme Court said this right to speedy trial is a fundamental right. Now, let us understand this. Custodial torture against children, you might have seen that custodial torture, that is second important component which frequently occurs in prison. Either prisoners are tortured by jail authorities, prison authorities, by jail superintendent, by warden of jail, by constable police who are working in jail. Either they are inmates of the prisoners. Many times cases are reported that inmates of the prisoners, they also fight with each other, and as a result of that, but in most of the cases, prison authorities are involved in custodial torture. There is a leading case on this point which I would like to refer, this Munna vs State of UP, IR 1982. You look at your screen. This case is a leading case on child abuse. Child abuse, physical violence, psychological violence. Juveniles who are in conflict with law, who separation of juvenile, I will discuss one by one. Separation of juvenile from abandoned children in district juvenile home. You see what happened in Munna case. This is also known as Kanpur jail case. What actually happened in Munna case, a child against whom a sodomy was committed in Kanpur jail. The matter was brought into the notice of Supreme Court that there was no separate prison, there was no separate cell for children, and when a child who is conflict in law, child in conflict with law means a child who has committed crime, who has breached the law, there must be a separate prison for him. Otherwise, a child who is in conflict with law, who has breached the law, if he is kept along with a hardcore criminal, so there is quite possibility that even that child may become a hardcore criminal. So, in order to avoid that thing, the provision is that, law is that child must not be kept along with habitual offender. So, there should be a separate provision. So, when inquiry was conducted, just to rule out the allegations, when inquiry was conducted, the allegations were found true. That cases of sodomy, infectious diseases, and the plight of inmates of prison was also highlighted in this case. That is in Kanpur district jail, when inquiry was conducted, the allegations were found true. So, Supreme Court, in this case Supreme Court issued various guidelines for juvenile, for those children who have been arrested by the police, who have breached the law. So, Supreme Court asked the government, state government, that state government should provide action taken report in this case, that what action would be taken by the government with regard to juveniles, whether government is willing to keep them separately. So, government should provide report before the court. The important thing is that you see this, it was the year 1982 when Juvenile Justice Act was not enacted by the Parliament. Juvenile Justice Act was enacted by the Parliament in 1986, and Parliament, Indian Parliament for the first time enacted Juvenile Justice Act 1986, and by that act, by that statute, a clear cut provision was made in that statute that district administration will have to ensure that juvenile must be kept separately, so that they cannot become habitual offender. So, that is why, and since then we are having district juvenile homes, and you might be surprised to know that juveniles must not be kept along with abandoned child. Many times you might have seen that abandoned child who lost their parents in any fair or railway platform. So, abandoned children, they are also kept in district reformatory home, district juvenile home. So, the problem is with this case is Supreme Court for the first time issued direction to the government concerned that government should ensure that juveniles should not be kept along with the habitual offender, and there should be separate jails, separate district reformatory home for juveniles. And in 1986 Parliament enacted Juvenile Justice Act. Since then we are having that kind. Now come to another aspect, NHRC report. With the help of NHRC report, we will try to understand that what is the actual position of custodial violence in prison. NHRC, I have referred this report, NHRC report 2021, National Human Rights Commission report. You see, we are having two important agencies, NHRC, National Human Rights Commission, and NCRB, National Crime Record Bureau, NCRB, National Crime Record Bureau. But here I am referring NHRC report 2021. According to this report, 151 people died in police custody during 2021, 1569 deaths in judicial custody. Safeguards, what are the safeguards provided in the statutes? If judicial custody if people are died in police custody, or inmates of the prison are died in judicial custody in prison, then what are the remedies? Remedies are provided in section 222 IPC. Punishment for an officer who maliciously confines any person. So, section 220 IPC is there. The family member of the deceased, they can invoke section 220 IPC, they can file FIR, they can lodge FIR against that police officer who has arrested that person maliciously. So, for malicious prosecution, they can initiate proceeding against them. 330 IPC talks about punishment for causing hurt to obtain confession. So, they can also lodge FIR against police officer for causing hurt to obtain statement. Role of NHRC and State Human Rights Commission is important. National Human Rights Commission and State Human Rights Commission have been established only to protect human rights of the citizen of this country. So, they can take action against the jail authorities. Though NHRC can recommend only a State Human Rights Commission, these two important commissions are only recommendatory body. So, wherever violation of human rights are reported, NHRC comes forward, SHRC comes forward to protect human rights of that citizen or group of citizen. But NHRC has referred this thing, the statistics of NHRC is not satisfied. Protection against inhuman treatment, as I have referred in this slide, as I have already highlighted in previous lecture, that Article 5 talks about right against inhuman treatment. Sunil Batra vs. Delhi Administration, AIR 1980 Supreme Court, this is very leading case. I have already mentioned this case. In this case, later petition was accepted by Supreme Court. And second case is Hussain Ara Khatun vs. State of Bihar, AIR 1980, which I have just referred. Undue delay, that is undue delay, and right to speedy trial, that is under Article 21. Right to fair trial. So, now let us understand this case, Sunil Batra case. So, here I would like to highlight the inmates of Tihar prison. In Sunil Batra case, what happened? You see, Sunil Batra wrote a letter to a judge of Supreme Court by highlighting the plight of his guilty and other inmates of prison against whom Tihar Jail Authority had taken illegal action. So, Sunil Batra wrote a letter to a judge of Supreme Court by highlighting the plight of Tihar Jail, and that letter was accepted by Supreme Court as a later petition under Article 32 of the Indian Constitution. Whatever allegations had been made by Sunil Batra in that letter, Supreme Court appointed a judge to inquire the matter, allegation, and allegations were found true. Then Supreme Court in this case held that protection against inhuman treatment, that is international commitment, which Indian government had already expressed international commitment by putting its signature to that international covenant, ICCPR and UDHR, Universal Declaration of Human Rights, Article 5 talks about right against inhuman treatment, cruel punishment. So, protection against inhuman treatment is human right, and where jail authority, Tihar Jail Authority has failed to comply this human right, this fundamental right, it must be considered as violation of fundamental right guaranteed under Article 21 of the Indian Constitution. So, a person who has committed crime has been put behind the bar cannot be deprived from his precious right. A person who cannot be deprived from his precious right only because he has committed a crime, and crime is of such a nature which is not so heinous. So, that person must be provided all the human rights which he can avail as a human being. So, in this case Supreme Court considered that letter as and accepted that letter as a petition and issued a direction against the government, and also Supreme Court held that right against inhuman treatment, that is essential component of right to life and personal liberty. Every person, even prisoners, are entitled to live with human dignity. They cannot be deprived from their precious right guaranteed under Article 21 of the Indian Constitution, right to life. Since there was no apprehension that accused might abscond from the Tihar jail, in spite of that, prison authority had put him on bar feeders. So, and in a isolated cell. So, Tihar Jail Authority had violated statutory norms, and by putting that accused in isolated cell, by putting him on bar feeders. So, that is a kind of cruel punishment, that is a kind of inhuman treatment which is prohibited by that Article 5 of UDHR and Article 21 of the Indian Constitution. So, in this way you can also refer this case. Now, come to another important aspect of rights of prisoner, right to fair wages. I have referred this right to fair wages case. The name of case is Ghayasuddin versus State of Andhra Pradesh, AIR 1997, Supreme Court. I have referred Article 23 which talks about forced labor. You all might be knowing that forced labor is prohibited. Even prisoners are entitled to get fair and minimum wages. Minimum Wages Act 1948 is there. So, under trial and convicted both. So, now I would like to discuss the fact of this case, Ghayasuddin versus State of Andhra Pradesh, AIR 1997, Supreme Court. What happened in this case? Supreme Court referred two important provisions. One, Article 23. Article 23 talks about forced labor. Article 23 talks about protection against bonded labor, compelled labor, forced labor, begar, that is prohibited under Article 23 of the Indian Constitution. And Minimum Wages Act, second important statute which was referred by Supreme Court in this case, that is Minimum Wages Act 1948. So, Article 20, let us discuss one by one. Article 23 of the Indian Constitution talks about right to fair wages, and Article 23 prohibits begar, any kind of forced labor, involuntary work without payment would come within ambit of Article 23. So, even prisoners are entitled to get fair wages in the prison if they are compelled to do any work, if they are compelled to provide their services to the prison authorities. Prison authorities are bound to provide, to maintain, to ensure Article 23 of the Indian Constitution. On the other hand, the Minimum Wages Act 1948 talks about minimum wages to the workers working in a factory or industry. And you see, this Minimum Wages Act is a mandate for industrialists, for those employers who have established their factories or industry. They are bound to provide, they are bound to give minimum wages to their workers. Otherwise, it would be violation of Article 23 of the Indian Constitution. It would be violation of their fundamental right. So, Supreme Court in this case, in Ghiyasuddin case, Supreme Court held that where prisoners are compelled by prison authorities to do a particular work in the prison, they are entitled to get fair wages. They can't be deprived from that benefit. Otherwise, it would be violation of their fundamental right. So, you see, the Supreme Court has made a clear-cut distinction between under trial prisoner and convicted prisoners. So, you see, where you need to understand one thing, that where rigorous imprisonment is a part of punishment and convict are compelled to do any work, then in that case it is not obligatory for the state to provide wages to that convicted offender upon whom court has inflicted rigorous imprisonment, imposed rigorous imprisonment. So, in that case authority is not bound. Otherwise, where simple imprisonment is awarded by court to a prisoner and prisoner is compelled to do any particular work in the prison, so jail authority is bound to give fair wages. This is another important area which you can refer in your. Now come to this precious right to legal aid. Right to legal aid. So, you see, this is another important area where state can play important role in protection of human rights of the prisoner, human rights of the inmates of the prison. Right to legal aid. I have highlighted this Article 22, 303 CRPC. Right to have a counsel of own choice. This is fundamental right. You all might be knowing Article 22 talks about right to have a counsel of our own choice. And second point is, no one should be punished without unheard, principle of natural justice. So, without legal representation, case cannot be decided, whether it is a civil case or criminal case. So, legal representation is necessary. Article 22 talks about legal representation, legal aid. Article 30, section 303 CRPC talks about legal representation in criminal case. So, without legal representation in criminal case cannot be decided by the criminal court. And Supreme Court has already recognized that in M.H. Housecott versus State of Maharashtra, that right to free legal aid, that is essential component of right to life or personal liberty. So, you will have to understand all these things in the light of judicial pronouncement. You will have to understand all these things in the light of constitutional provision and statutory provision. Two important things which I have just referred, Article 22 and 303. In civil cases, you all might be aware about Order 33, which talks about pauper suit, indigent suit. So, poor people who are unable to engage their counsel in the court of law, who are unable to pay court fee in civil case, they are entitled to get justice in their civil cases, and it is the duty of civil court to provide them advocate free of cost in civil case. Since I am talking about custodial violence in prison and human rights issues, so that is why I have highlighted only that aspect of human right which is directly connected with inmates of the prisoner. But it would be pertinent to mention here CPC also, you all need to understand it. But now let us see what is the mandate of Article 22 and 303 CRPC. You see, you all might be knowing that there is RD alteram partem, principle of natural justice. No one can be punished without unheard. Without giving opportunity of hearing, no action, no judgment can be passed. This is a principle of natural justice, RD alteram partem. This is Latin maxim, and the English meaning of this RD alteram partem is hear the other side, party must be heard. So, without giving opportunity of hearing to a person, if decision is taken, it would be injustice. Without giving opportunity of hearing to the aggrieved, without knowing the allegation, without so this is a principle of natural justice. And Article 22 of the Indian Constitution says that every person has right to take legal assistance from his counsel. Every person is, it is a fundamental right of every person to engage a counsel of his own choice. Engaging a counsel for defense, this is a kind of legal representation, and this is a kind of compliance of principle of natural justice. By this, we pay due respect to the principle of natural justice, RD alteram partem. So, legal representation provides an opportunity to the accused to represent himself, to discard, to reject the allegations made by the opposition respondent. So, 303 CRPC talks about legal representation, that every accused has right to be represented by legal expert, by a counsel. Without legal representation, criminal court cannot decide the case. Criminal case cannot decide. If criminal case is decided by criminal court without legal representation, it would be violation of statutory provision as well as it would be violation of principle of natural justice. So, you all need to understand this, section 303 and 22 of 22. Now, how legal representation is necessary? You see this, the concept of legal representation, this is a fundamental right, and this precious right is available to an aggrieved even against administrative adjudication. Even administrative authority cannot decide any administrative dispute without legal representation, without giving opportunity of hearing to the aggrieved. So, what is the reason behind legal representation? You see, legal representation, it gives liberty, it provides an opportunity to an aggrieved to defend himself, to negate the allegation, to reject the allegations made by his opposite party, and he can prove his innocence before the authority concerned against whom his allegations or he is being heard. So, legal representation is necessary. Article 22 and 303, right to free legal aid is also essential component, as I have already highlighted that prisoner who cannot afford court fee, cannot afford advocate fee, that poor prisoner must be provided free legal aid. Now, come to this next slide. I have referred this custodial violence against women prisoner. This I have chosen one case, Sheila Barse, you see, versus State of Maharashtra, AIR 1988 Supreme Court, Rudal Shah versus State of Bihar, AIR 1982 Supreme Court, and Prisoner Act 1890, Prison Act, not Prison Act 1894, separation of prison for women offender. So, now let us understand this custodial violence against women prisoner, and Prison Act 1894, right to food, right to medical aid. So, Prison Act 1894, this is statute, and this statute provides two important rights to the prisoner, that is right to food, right to medical aid. Under this statute, Prison Act 1894, any prisoner is entitled to get medical aid and food free of cost. Now, separation of prisoner, women prisoner from male, Prison Act 1894, this statute makes clear cut provision that female offender shall not be kept along with male offender. There should be separate prison for female offenders, and female offenders cannot be put along with male offenders. There is a clear cut provision for the separation of female offenders from male offenders under this Prison Act 1894. Now, let us discuss this case, Sheila Barse vs. State of Maharashtra, IIR 1984 Supreme Court. You see what happened in this case. In this case, the plight of women prisoners was highlighted in this case, that women prisoners, they had been kept along with male prisoners, and particularly in the state of Maharashtra, the women prisoners, they had been kept along with the male prisoners. There was allegation against the prison authorities that prison authorities had failed to make separate provision for female offenders. As you might be, then Supreme Court observed in this case that state government should ensure that there should be separate cell, separate prison for female offenders. Female offenders should not be kept along with male offenders. Another important case on this point is Ruddal Shah vs. State of Bihar, AIR 1982 Supreme Court. So, many of you might be aware about this case, Ruddal Shah case vs. State of Bihar. What happened in this case? Ruddal Shah, in Ruddal Shah case, Ruddal Shah was to be released in 1968. I just want to you look at your screen, and with this, with the help of this, Ruddal Shah vs. State of Bihar. So, what happened in this case? Ruddal Shah was to be released in 1968. He was to be released in 1968, but he had to remain in jail till 1982. So, you see, he had to remain in jail for more than 14 years. Due to negligence of jail authorities, he had to remain in jail. So, he filed a petition when matter was brought into the notice of Supreme Court that Ruddal Shah had to remain in prison for more than 14 years. How jail authority was negligent in this case, and Supreme Court said that where jail authority failed to release him, Ruddal Shah, within time, government concerned was liable for what? For the negligent act of its officials, and state government was directed to pay compensation to the accused. In this way, Supreme Court issued a direction to the state government concerned that state government is vicariously liable for the negligent act of its officers. He should have been released, Ruddal Shah should have been released in 1968, and he had to remain in jail for more than 14 years. So, the mental agony or the sufferings or the plight of Ruddal Shah was taken into account by the Supreme Court, and Supreme Court directed the state government to provide compensation to Ruddal Shah. And in this way, Supreme Court for the first time recognized that a right to get compensation, that is a fundamental right, and right to get compensation is part integral component of right to life or personal liberty guaranteed under Article 21 of the Indian Constitution. So, in this way Supreme Court recognized that right to life and personal liberty also includes a right to live with human dignity. It does not include right to live with animal existence. So, state government was directed to provide compensation in this case. I think I have covered each and every aspect of custodial violence in prison and human rights issues, right from the Prison Act 1894 and custodial violence in prison and human rights issues. I have also covered UDHR Article 5 of UDHR, ICCPR International Covenant on Civil and Political Rights, Article 21 of the Indian Constitution, Article 22, Section 303 CRPC, legal representation, right to have a counsel, right to engage a counsel, and Khatri versus State of Bihar, Bhagalpur blinded prisoner case, Hussain Ara Khatun case, Ruddal Shah case, Sheela Barse State of Maharashtra, and Section 304 CRPC, Article 22, right to free legal aid, AMH Hoscott versus State of Maharashtra, AIR 1978, and statutory provisions which are given in the Prison Act 1894 in order to prevent prison atrocity, in order to prevent custodial violence in prison. This Prison Act 1894 makes it clear that neither jail superintendent nor any officer of the jail can violate the rights provided in this statute. For example, right to medical aid, right to food, right to legal aid. So, these are certain safeguards provided in this statute, and now time has come to modify, to rectify, to amend this century old Prison Act 1894, and Supreme Court has already highlighted the significance of amending this statute in Ram Murthy versus State of Karnataka. In that case, Justice V. R. Krishnaiyer said that this century old Prison Act needs to be amended, and I think that is very good remark which Justice V. R. Krishnaiyer has made in Ramurthy versus State of Karnataka case. I have also referred Ghayasuddin case. In Ghayasuddin versus State of Andhra Pradesh, Supreme Court has said that right to fair wages is also a fundamental right of prisoners. Particularly under trial prisoners are entitled to get fair wages. Otherwise, it would be violation of Article 23 of the Indian Constitution. Minimum Wages Act 1948, I also refer that Act. So, with this I think I have covered each and every aspect of custodial violence of the prison and human rights issues. With the help of judicial pronouncement, with the help of statute, with the help of constitutional provision, I tried to explain you all the relevant case laws, statutory provision and constitutional provision, so that you can get entire information about custodial violence in prison and human rights issues. I do believe that you all have understood the things which I have just discussed in this lecture. If you all have understood this case, if you all can memorize these case laws, judicial pronouncement, I think there would be no doubt in saying that you can clear any kind of competitive examination in which you are going to appear. So, with this I would like to conclude this lecture, and thank you all.
Hi, my name is Gillette Sam and I teach sociology at IIT Kanpur. Today I am going to tell you about an important debate that is occurring around the concept of globalization. Now, uh, within the study of globalization, there are two sets of people. The first set of people argue that globalization is very real. It's something that is happening around us all the time, and in fact, it's something that is gaining strength over time. The second set of people, and the first set of people are called the globalists. The second set of people are not so convinced that globalization is something real, and they are referred to as skeptics. Now, the skeptics argue that unlike what the globalists would have us believe, that there are things and ideas and people that are traveling across the world, across multiple borders, and that we live in an interconnected world, actually, there are many parts of the world and many types of people who are completely left out of these kind of global flows. So they would give you the example of typically indigenous communities who live across the world. And they would argue that if you look at the lives of indigenous communities, particularly tribes that are quite isolated in terms of their physical location, their lives continue without their participating in any kind of global flows. To this, the globalists would respond that even though people may live in isolated and remote locations and they may not be directly involved in global flows, their lives today are still being influenced by events that are happening at a global scale. You can take the example of climate change. So, for instance, if there is an indigenous community that has no contact with anyone else in the world apart from themselves, but they live in an area which is experiencing an increase in sea levels, an increase in the temperature. All of this may be attributed to people in neighboring countries, or actually rather events that are happening across the globe. So in that sense, even though you may not be directly participating in global flows, your everyday life is affected by what is happening around the world. Another argument that the skeptics make is in regard to what happens with the nation states. Now, initially, when discussions about globalization started, and we are talking about the 1990s, the expectation was that the nation state as an entity is going to wither away. It's going to cease to be important. Now, skeptics could point out to the world today and say, well, nation states are still important. We still live our lives based on which nation we were born in or which nation we have citizenship in. Their rules and regulations are still important for us. To which globalists would argue that this expectation that the nation state will cease to be important, that itself is a fallacy. Rather than facing a situation that the nation state becomes less important over time, we actually may be headed towards a situation where, in addition to the nation state, there are other laws which become important to our lives and they shape our lives on an everyday basis.